It is December 20th, 2025. This is the Court Gallery. Welcome to the Weekend Review. Ladies and gentlemen, welcome back to another live from the gallery. This time we're doing it for the weekend review. And we have some crazy cases for you today. I just want you to buckle up because we're going to spend a large part of the presentation here with one particular defendant, Ms. Blades in Kansas. And man, she's been working hard for the last few months to really try and heave off the judges, the 13th District Court. And ladies and gentlemen, we're going to start off with a hearing in August. We're going to move quickly to another hearing that happened just this past week. And once we're done in Kansas, then we're going to move on to a little place we all love to call Planet Washington. And ladies and gentlemen, I'm not sure who the judge is here, but he had his hands full with some small claims matters just yesterday. We're going to check into all of them. And ladies and gentlemen, it all starts right now. I think. Wait. God damn. All right, we're gonna try and start it right now. Let's do it.
Will be on the record in case number 2024 CR 112, State of Kansas versus Ginger Ray Blades. Also case number 25 CR 69, also State of Kansas versus Ginger R. Blades. County Attorney Jill Gillette representing the state in both cases. Attorney Joseph Favre representing the defendant in both cases. This is a show cause hearing why the defendant's probation should not be revoked. Mr. Favre, does the defendant wish to challenge the allegations alleging she violated her probation?
Judge, I think at this time it'd be prudent to set us for an evidentiary hearing in that matter, as well as a trial in 25 CR 69, which is our misdemeanor control case. And it may end up that we don't need the evidentiary once we have a resolution, but I think that may be the way to go at this point.
Well, I showed this was for evidentiary hearing that she had previously appeared for first appearance docket June 3rd and was given today's date. for evidentiary hearing. Well, she was actually given July 8th, and then the July 8th was continued to today at her request, and there was no objection to that. So, Ms. Gillette, any objection to continuing this a second time on the show cause?
No, Your Honor.
Are we, am I getting out today?
Well, Judge, I'd also like to address the issue of Miss Blades' bond as well.
And I think you've mentioned that. All right, how much time are you needing to set this over to? 30 days?
Well, I was thinking, I don't know, I was thinking maybe we should special set it. Do you normally do those warrant to show causes on the PHC docket, or how does the court do that?
I think I usually do. Misty, what do you have for us for a show cause hearing date? And it can be a special setting if you have one.
Okay, well, are we gonna, on the other one, is it gonna be a status, or we need an evidentiary hearing on it?
Then we will see. But it will be
Judge, maybe it'd be best. Could you put me in a quick breakout with Miss Blades real quick, and then move on to another case, and I'll come back.
That'd be fine. Okay, if
That's
the county jail, Miss Blades needs to watch for an invitation to a breakout room, we're gonna take a recess on both her cases. Ms. Short, you wanna take up yours then? Back to the person in the county jail. Who is that again?
That's Miss Blades, Your Honor.
We ready on her now?
Yes, Judge, we have a change in our announcement.
All right, back on the record in 24 CR 122 and 25 CR 69, each caption state of Kansas versus Ginger Ray Blades. Please announce appearances.
2 and 3.
Yeah, Your Honor.
Fourth, the state appears by Joe Gillette, County Attorney.
So I got to get that paid by tomorrow.
And the defendant appears in person, in custody, and with counsel Joseph Favre. Mr. Favre, you've had a chance to meet with your client privately.
Yes, Judge.
You said you have a change of announcement. Is that right?
We do, Judge. Yes. Miss
Okay.
Blades will be pleading no contest to 25 CR 69, which is the new case, and she will be admitting to the violations in 24 CR 122. And we have a joint recommendation for disposition and sentencing in those two cases.
All right. And what would that be?
Judge, in the 24 CR 122, state will agree to reinstate Miss Blades. I'm not sure if a probation extension will be necessary, but if the state recommends that, we don't oppose that. And in the new case, we are recommending 12 months underlying, 12 months probation to run with her 24 CR 122 case.
No fine. Okay. All right. That's your agreement, Miss Gillette.
It is, Your Honor.
Ms. Blades, is that your agreement?
Yes, Your Honor.
Very well. In case number 25, CR 69, you are accused of violation of a protection order issued as a condition of pretrial orders on that you violated that on April 17th of 2025 in Greenwood County, Kansas. How do you plead to that?
No contest, Your Honor.
By no contest, you're not admitting the charge, but you're not denying it or wanting to take it to trial?
Correct.
No. Are the parties stipulating to Deputy Blake Fisher's affidavit in this case?
Yes,
We
it's
are, Your Honor.
stipulated.
Okay. I have that in front of me that on Thursday, April 17th, 2025, he was working and dispatched to 224 North Main Street, Eureka, Greenwood County, to take a violation of a no contact order report. And I am well aware of that through this and another case. I do find that the defendant, Miss Blades, is anyone making you enter this plea today?
No, Your Honor.
I find that this is a knowing and voluntary plea entered today, and that the defendant, there is a stipulated factual basis in the affidavit to support the no contest plea. I find the defendant guilty in 25 CR 69. Or guilty as charged, violation of a protection order. And then going back to 24 CR 122. That had been a violation of a protection order, but it had gone to conviction and sentencing. So we are here today on a
She's stipulating to the revocation, Your Honor. After her
Yes, sir.
stipulation, we will be recommending that she's been in custody about 60 days, and we count that as a sanction, reinstate her to a new term of 12 months probation with an extension from today. That 12 months would run with the 12 months in her 69 case, and she would report to court services as no contact with the victims, absolutely no contact.
All right, so Ms. Blades, the state's alleging in the warrant to show cause why your probation should not be revoked that you have failed to pay all fines and costs associated with this case as directed. Is that true?
I've made 2 payments, Your Honor, totaling $176, I believe.
But not
So I have
as,
started to make payments. If they and I can bring proof of that to my first probation if I send them.
well, the next allegation is that you are ordered to report to the CSO as directed and did not. Are you contesting that issue?
I initially had made contact and then showed up for my first probation. I did miss my second probation meeting, and that's why I've been sitting. But I won't miss probation. I won't be any problem to you, Your Honor, I promise.
The reason I'm asking you if you stipulate or agree is because if you disagree, you have the right to an evidentiary hearing and make the officers testify. So are you agreeing to these violations or disagreeing and wanting an evidentiary hearing?
I had only missed the second one.
All right, so you agree you missed one, but not 2. Is that what I'm hearing?
Correct, Your Honor.
How
And I
about,
have made payments.
okay, how about the what, but not all the payments as ordered? Is that what you're saying? You made
Correct. I do owe you guys some payments.
All right, and number 3, they're saying you failed to obey all federal, state, and local laws. That in other words, you violated the law. Are you agreeing or disagreeing that you've been convicted of any new charges since you were put on probation?
I have it's in Lyon County. It was a no tag, like suspended tag or something like that. And we've resolved that issue, and I just owe them fines now. But yes, I did. I had a tag that was expired.
All right. So you understand you do have the right to challenge these violations and to take them to evidentiary hearing. Do you understand that?
Correct.
But knowing that, you want to waive your right and agree that you did have these violations.
Correct.
And do you understand that your probation could be revoked and you could be ordered to serve your sentence for these violations?
Correct.
You understand, even though the attorneys may have worked out a plea agreement, I am not bound by that agreement.
Yes, ma'am.
Okay. And is anyone making you waive your right and stipulate to these violations by any threats or promises?
No, ma'am.
Okay. All right. Well, I'll find that you do knowingly and voluntarily waive your right to hearing and stipulate to the violations. Accordingly, I find you are in violation of your probation. Now, the parties recommend we kind of have a redo. We kind of start over and say, okay, you screwed up, but we're going to let you start all over with another probation.
Thanks.
No, thank them, but don't thank me because I haven't done that just yet. I don't like that idea, Miss Blades, because I need something to tell me that it's going to be different if I do let you redo. What are you going to do differently? And I know the facts behind this case, why you were told to stay away from certain people. What's going to be different, Mr. Attorney? Do you have anything different to assure me that she's not going to go right back out and do this again?
Yeah, that's a great question, Your Honor. I think, first of all, she, as Ms. Gillette said, she's already done a chunk of time, and that's been a cost to her, and hopefully that's been a wake-up call. I mean, she has not enjoyed her 60 days in the county jail. I think in addition to that, it's hard to say for sure, what motivates people to make contact, but I've gone over that with her multiple times, and I've spoken to the person who has called me on her behalf. which is her current boyfriend, and both of them have assured me she's no longer going to make contact. I don't know what else I can do to stop that. We would agree to some kind of GPS monitor if we thought it was helpful, but the allegations aren't physical contact; they're digital. So I don't. Anyway, I'm not sure what else we can do on that.
Well, Miss Gillette, you entered into this plea agreement and you're as familiar with the ugly facts behind this case as I am. Apparently, you feel confident that she won't violate her probation again?
Judge, I believe 60 days in the Greenwood County Jail has hopefully taught Ms. Blades what happens when you make contact.
Has it, Miss Blades?
Yes, Your Honor. Yes, Your Honor.
Has it taught you that if you get this rare redo, you better not go out and blow it because you won't get out as easily next time?
Yes, ma'am. Yes.
All right. Miss Morgan, you've been trying to supervise her apparently.
Yes, Your Honor. She actually was transferred to Lyon County Court Services as well.
And would that be your intention this time again, because she lives in Lyon County, transferred to Lyon County for supervision?
Yes, Your Honor, if they accept her back.
Do you have any reason to know one way or the other if they would?
I don't, Your Honor.
I'm sure they will.
Did they ever file charges based on the similarity of charges that we had here?
I don't believe so, Your Honor. I think it was just in Greenwood County.
Well, I remember there were allegations involving Lyon County as well. All right. Well, Miss Blades, I'm not so sure I'm going to trust you, but it's up to you to prove me wrong or prove me right, whichever way it goes.
Okay.
But because the attorneys do have this faith in you, I'm going to hope that time in jail has convinced you don't want to spend any more time there than you have to.
Thanks,
So,
Your Honor.
Finding you in violation of your probation, I will order you to serve to the credit for the amount of time you've already served. You said she's been there up to 60 days or almost 60?
It's been over 60, Judge. She was taken into custody originally on June, I want to say 5th.
May 28th.
Oh, May 28th. I'm sorry, I'm off by a week. So it's been over 60.
I'm going to order that you serve 90 days with credit for any time served already, which sounds like it's going to be the bulk of the 90 days. And at the end of that, I'm reinstating probation or parole, as the appropriate legal term might be. But that will continue to be supervised, and you will report as directed, and you will not violate any of the prior terms as they are being made the continuing orders of the court in this new supervision chance you have.
Thanks, Your Honor. And I did do 25 days prior to this. I'm
saying 90 days this time around.
Oh, okay.
And your probation will be extended for 1 year from today.
Judge, are you ordering any attorney's fees for today in the revocation?
As I recall, you don't have any job, do you, Miss Blades? Did you get a job that pays money?
Yes, Your Honor. I am in nursing.
So
I work for Impact Home Health Care. I'm not sure. I just have to. Yeah, it just is. When this is all over, then I can go back to work.
What do? You work with the sick and the dying?
I work with people in their own homes, and I help them clean their houses and make them food and things like that. People that are elderly.
And you would have access to drugs and things of that sort. Well, I'm going to order that you not possess any drugs that are not yours, prescribed or over the counter. So you may not be able to give them medication. This isn't a drug case, but I think it's a good order of the court to make that you don't do that.
Okay, Your Honor.
Judge, on the 69 case, are you ordering court cost, booking fee, and any attorney's fees in that case?
On the 25 CR 69 case, I will order as agreed upon by the parties which was a 12-month sentence with a 12-month reporting. I'm going to order reporting probation, no fine, attorney's fees waived, but yes, I am ordering court costs of 158 and booking fee of 45. Probation can run concurrent, but the sentences will run consecutive.
Are you ordering the probation fee in the 69?
Yes.
Okay.
In both cases, she can pay that. All standard conditions will prevail. No alcohol, no illegal drugs, don't violate any laws, those sort of things. Reasonable curfew and travel restrictions as customary. Ms. Blades, I didn't ask you too much about that case. In 25 CR 69, how do you plead to the violation of the protection order on April 17th of 25?
We did a no contest plea on that.
That was a no contest, Judge.
Oh, we stipulate
In the affidavit, okay.
Right.
All right. And that would give rise to that second case, the revocation as well, that you did have a violation of the law. Okay, anything else we need to address, counsel, on this?
No.
No, Your Honor.
And Ms. Morgan, will she be reporting to you, or do you want me to transfer her to corrections?
No, Your Honor, she needs to report to me and then I can get her transferred to Lyon County. Is there any way we could have a breakout room with the jail?
Jill, can you do the breakout room with her and her probation officer?
Yeah.
All right, Missy, let's do that. We are on the record in the 13th Judicial District, District Court of Greenwood County, Kansas. This matter comes on for motion to revoke probation in two cases. GW 2024 CR 122, State of Kansas versus Ginger R. Blades, and case number GW 2024, oops, it's the same case number, 25 CR 69, also State of Kansas versus Ginger R. Blades. Please announce appearances.
May it please the court, the state appears by Jill Gillette, County Attorney.
Ms. Blades appears with counsel Joseph Favre. She's in the Greenwood County Jail.
Very well, and we also have Jessica Morgan, CSO1, probation officer in these matters. And Mr. Favre, are there any announcements? Does your client wish for a hearing?
So there is, Judge. Speaking to Ms. Blades, at this time she's requesting for a new attorney to be appointed, and she's requesting for a continuance so that that new attorney can be appointed.
Ms. Blades, you have anything you want to say on your own behalf?
Yes, Your Honor. I have spent enough time in here for being a good mom, and I need a better option than that. I mean, third party contact was not my fault, and the fact that a guy that I was seeing texted the child, and so I'm just hands down.
Hold on. So you basically don't like what Mr. Favre has advised you or told you?
I just need more time to find new options, I guess. I've tried. I've done everything that I can, and I am depressed at this point, and I just need a continuance or whatever, because Okay,
well, let me tell you what I think you're saying. I think I'm hearing you say you just don't like the results he's getting you.
It's not that. It's just, I just need a continuance. I do. I need a continuance.
For what purpose?
To hire new counsel.
Well, these cases have been going for a couple of years now. At least one of them has been going for a couple of years. The other one is earlier this year. I've always found Mr. Favre to be a very competent, exceptionally competent attorney, very diligent in fighting for his clients' rights. Now, I'm not prejudging you, but sometimes the clients don't give the attorneys enough to work with to get the results the clients work. That may or may not, or want. That may or may not have anything to do with why you're asking to have him replaced. I don't know. But I'm going to deny the request unless I have some good reason to grant it, but just because you don't like the results you've had to date, that's not going to work.
Well, I also want to continue into your honor so that I can possibly make the option to hire my own attorney.
Well, you've always told me you didn't have a job or you didn't have the money to hire an attorney. What's changed since the last time you applied for court appointed?
Maybe I have a friend that'll help me. I mean, I can try and call out and try and make this decision. I'm trying to work with my options here. I'm stuck in a jail.
Well, you're stuck in the jail because there was a warrant issued to show cause why your probation should not be revoked. But let's focus on whether or not you need a new attorney. And I don't believe you do.
Do I have the option of having it reinstated?
Well, I can't tell you that. I don't know where we are on this. I can tell you you have the right to challenge the allegations and say they're not true, that you have not violated your probation. We can go to an evidentiary hearing and Ms. Gillette can present the evidence. Ms. Morgan is here to testify to what she has alleged in the request. Mr. Favre is here to help you to the best of his ability to show that you haven't violated or to put doubt in the testimony. But ultimately, I have the responsibility of hearing the evidence, both the state's and yours, if you wish to present any. And I have to determine, did you violate or did you not? If you didn't, then I'm back on your merry way to probation. If you did violate, then I have to decide what to do about it. Do I reinstate you? Do I put you in jail to finish your sentence? Do I do some combination like we did the last time you were here on a warrant to show cause, where you did, I believe, a 90-day sanction and then I put you back on for a year? But that's just going to depend on what I hear.
Okay, can we break out for a minute and let me visit with Favre then for just one more second, Your Honor, and then we'll get back together.
You can take whatever time you want. But again, if I'm hearing you correctly, you want a new attorney because you don't like the results you've had to date.
No, it doesn't have anything to do with that. I just wanted a little more time to think about my options since these were just presented. But if I could speak with Favre because he's put forth the effort.
We generally address folks by Mr. and Miss. Well, this was filed October 28th of 25, and it is now December 16th of 25, and you have not had enough time to think about your options and your opinion. Is that correct?
Well, I haven't been able to speak with Mr. Favre. I've tried to call. I've had other people call, but we haven't had a chance to get together because I know that he's a busy man. So I'm just being respectful.
Jail, correct?
Yeah.
Yeah, you've been in jail. I know at one point I ordered a no bond hold because you kept failing to come to court. I don't know if that's been this issue, but that's been a problem, I'm sure. All right, yes, you certainly can have a breakout room to talk to your attorney. Mr. Favre, I'm denying any requests at this point to allow you to withdraw.
Thank you, Judge.
Thanks.
You're welcome. You're welcome. So, Missy, if you'd please put Greenwood County Jail, Joseph Favre in a breakout room so they can talk. We are back on the record in both Greenwood County case number 2025 CR 69 and Greenwood 24 CR 122, each captioned State of Kansas versus Ginger R. Blades, all parties appearing as before. Miss Blades, have you had enough time to talk to your attorney?
Your Honor.
Yes?
Yes, ma'am.
And do you have any questions of what we're doing here today that you want to address with the court?
No, I just think that we were talking about if I've done something in order to, since it's only been a month and I've had some issues with being away from everything and not having a way out here and Lyon County not taking on my case and then having a dirty UA, maybe
Ginger.
if I've done something wrong, treatment of some sort. So I think that's where we were headed with it, but I'll let him.
As I say, Miss Blades, he is appointed to represent you. I know he's very experienced. Do you want to let him do that, or are you wanting to represent yourself?
Oh, I just thought you'd asked me what we were Yeah. However,
I asked you if you had any questions for me about why
Oh.
we're here today.
oh, no. No, Your Honor, I'm sorry.
All right, do you need any more time to visit with Mr. Fibber about that?
No, ma'am.
All right, and are you ready to proceed on the warrant to show cause why your probation should not be revoked?
Yes, ma'am.
Ms. Gillette, are you ready to proceed?
I am, Your Honor.
All right, please call your first witness.
Judge, no, hold on. I apologize. We have a change in announcement. Ms. Blades will be waiving her right to an evidentiary hearing at this time and stipulating to the violations.
All right, then let me visit with you, Ms. Blades, again. Do you understand what the allegations are against you in these motions? And let me go over them with you just in case, so that we make a record that you understand what it is that the state is alleging. They are alleging that your probation should be revoked because, first of all, they say you failed to pay court cost fines as directed with a balance of $679. Your last payment on 2/26 of 25 for $134. I'm not going to ask you how you respond to that, but do you understand that that is what they're saying one of your violations is?
Yes, ma'am. And
Don't answer that just yet. You've got an attorney to help you. Do you understand number two? They're saying you failed to report to your probation officer as required on 10/21/25 and 10/28/25. Do you understand that? Not a response, but do you understand they are saying that's a violation of your probation?
yes, ma'am.
Okay. So they're saying that you failed to report and that that's a violation of your probation. Then they're also saying number three, that you violated your probation by committing new laws in the city of Emporia with criminal trespass now pending. Do you understand they're saying you did that and it's a third violation of your probation? Don't tell me if you did it or not. Just do you understand that's what they're saying you did?
Yes.
All right. And then four, they're saying defendant was placed on reporting probation for 12 months on November 19th of 2024. And on August 12th, 2025, and I'm addressing case number 24CR122, and I read this. Defendant was placed on reporting probation for 12 months on 11/19 of 24. On August 12th of 25, the defendant was found in violation of probation and reinstated for 12 months. The defendant has failed to pay on fines and fees since 2/26/25. The defendant has repeatedly contacted this officer. That would be Jessica Morgan. The defendant has repeatedly contacted this officer on wrong scheduled appointment times. The defendant failed to attend appointments on 10/21/25 and called 10 minutes before the appointment to reschedule. On 10/28, and as I recall, that may have been the revocation date of your hearing, but on 10/28 of 25, the defendant was 30 minutes late, and this officer rearranged her schedule to meet with the defendant. On 10/28/25, the defendant participated in a urine analysis and was positive for methamphetamine, amphetamine, alcohol, and THC. The defendant has pending case in Emporia Municipal Court for alleged charges for criminal trespass. On 9/30 of 2025, the defendant reported to this officer that the criminal trespass happened at a known bar in Emporia, Kansas, which is in violation of probation. This officer would request for the defendant's probation be revoked as she is not amenable to probation. Now, and then this is signed by a motion to revoke by Jill Gillette, but it's based on the original affidavit of your probation officer, Jessica Morgan, and it would be Miss Morgan when it's referring to this officer. Do you understand what I've just read?
Yes, ma'am.
Do you understand that Miss Morgan is here to testify that what I just read to you in the motion is a fact that you violated your probation in these regards?
Yeah, a month into it. Yes, ma'am, I do.
You understand that Miss Morgan would testify that you did these things and that they were violations of your probation?
Yes, ma'am.
And that's in 24CR122. And Miss Morgan, is that identical in the other case? It's pretty similar if it's not. Okay.
Yes, Your Honor.
Okay. And then Miss Morgan and the state is also alleging that you violated your probation in Greenwood 2025 CR69. And in this case, I just read from the motion to revoke filed October 30th, 2025 by Ms. Gillette based on the prior affidavit of Ms. Morgan and request for probation revocation. But in this case, the 69, I'll read from the warrant to show cause that was filed, and I would have approved. Let's see, I think I assigned that. Yes, that's the one where I gave you the 5,000 cash or surety bond in this case. And on it, it's alleged that you failed to obey all federal, state, and local laws, failed to pay your fines and costs, violated the order not to purchase, possess, or use alcohol or illegal drugs, that you violated the order not to enter any business whose primary source of income is for the sale of alcohol, that you violated the order not to associate with alcoholics, illegal drug users, or people who make alcohol and or illegal drugs available. And that's based on the allegations that I read to you from the other case. So do you have any questions for me or from Mr. Fibber about what the allegations are and that the state is wanting to revoke your probation in this case as well? Any questions? Okay. Do you need to speak to Mr. Fibber any further about anything I've just gone over with you?
No, we've already spoke, Your Honor. I think that he's willing to just speak with you, I guess, on
Okay.
however.
All right. I just want to make sure you understand that you were put on probation. And Ms. Gillette, Mr. Fibber, and Ms. Morgan, I do think it's important that we go back over a little bit of the history of this case. Let's see. Both of these cases kind of go hand in glove. In 24, CR 122, I think the motion to revoke probation pretty well sets out the hearing. In paragraph number 4, the defendant was placed on reporting probation for 12 months on November 19th to 24. Again, this is the 24 case. On August 12th, so that was November 24, and then on August 12th to 25, she was found in violation of her probation the first time and reinstated for 12 months. She was found to have failed to pay on her fines and fees since 2/26 to 25. And then the rest of it, we're back here on the second history. So she was placed on reporting probation 11/19 to 24 in the 122 case, and now we're here on a second show cause why her probation should not be revoked. And then she was found guilty of 2025 CR 69 after that. And then we had a show cause hearing in that case. And now we're here on a second show cause. So if everyone's ready to proceed, Mr. Fibber, you said you thought she had a stipulation.
She's going to stipulate, Judge. I think it's the first time up on 25 CR 69. I believe it's our second time on 24 CR 122.
And you may be correct. There's a lot of activity on both these cases. The complaint was filed May 19th to 25. Warrant returned May 28th to 25. Journal entry of plea and sentence August 19th to 25. Request for affidavit for request of probation filed October 28th to 25. And are you taking issue at the 69 case or the 2121?
The 60. I think the 69 case, Judge, is our first time here on that case
for
revocation.
Okay.
I don't think there's been a previous revocation on that case.
All right. I show October 28th to 25, the affidavit for request of probation, warrant to show cause on the 29th. Warrant issued, motion to revoke probation set for October 30th, and we've continued that over. Miss Gillette, that does appear accurate. You agree that this is our first revocation for probation on 69, but our second on 121.
It is, Your Honor. It's the second in the 24 case and it's the first in the 25 case.
And the 121. Okay. Well, you are going by years. All right. Okay. So there we have it. And so, Miss Blades, do I understand correctly that you understand you have a right to challenge these allegations and to require the state to present evidence?
Yes, ma'am.
But you also have the right to waive your right to hearing and say, no, Miss Morgan doesn't have to testify. That's what she would testify to.
Yeah,
And,
no, she doesn't have to testify. I just had wanted to request treatment.
all right. So, okay. So you're waiving you understand you have a right to hearing and you're waiving your right to that hearing today, the
Yes.
evidentiary portion. All right. And then the next step is, do you stipulate, that is, agree to these allegations? You can do that, and we can avoid the evidentiary hearing, or we can have the evidentiary hearing. But if you agree that this is what the evidence would show, there's no need to go on with the hearing unless you want to.
I think we had discussed that. I think it's Fabre's time.
You want Mr. Favre to address that? Mr. Favre, I don't know what that means. Is she stipulating that she did violate, but she wants you to present reasons why, for disposition, basically?
Yeah.
Judge, we went over that a lot, and she is, from what I understand, waiving her right to an evidentiary hearing, stipulating to the allegations listed in the warrant to show cause, and we're ready to proceed to disposition.
All right. Is anybody making you give up your right to this hearing and this testimony, Miss Blades?
No, Your Honor. I'm just ready to get it all settled.
All right. Is anyone making you agree that the evidence would show what's listed in this motion to revoke probation?
No.
Okay.
What did you just ask me? I'm sorry. What did you just say?
All right. Do you agree that the testimony in this case would show the violations alleged in the motion that I went over with you? Do you agree that that's what Miss Morgan would testify to, most likely?
That may be her side, but I remember it differently. But I mean, I can't prove that I called her on a weekly basis and all of those things, whenever I had contacted her repeatedly because I didn't have a car. So
you do or you do not agree that these are the violations?
Correct. That I agree that is how she sees it.
All right. And that's what the evidence would show if we went to hearing?
Yeah, most likely, Your Honor. Mm-hmm.
And you through your attorney would have the right to cross-examine that, but you wish to waive that hearing and proceed to disposition, and that's where Mr. Favre would start argument.
Yes,
Are we in agreement? Do we understand that?
Yes, ma'am.
All right. And you've talked about this with Mr. Favre, and you have agreed with your attorney. You want to waive your right to hearing and stipulate to the violations, or at least take a no contest to the violations.
Basically, yes, Your Honor.
All right. Well, I'm going to accept the defendant's waiver of hearing, and I'll accept more of a, I don't know that I'm hearing exactly a stipulation to the allegations as being true, but she at least stipulates that's what the testimony would be. As she said, that's what Miss Morgan sees it as. She may not see it that way, but she thinks Miss Morgan does, and that's what Miss Morgan would testify to. Did I say that right, Miss Blades?
Yes, Your Honor.
All right. So I'm going to find that you are knowingly and voluntarily waiving your right to hearing and stipulating to what the evidence would show, not to whether it's true or not, but that's what it would show. Now, do you wish to testify or present any evidence, Mr. Favre? Does she wish to testify or have you present any evidence?
Not on the stipulation, Judge, just on disposition.
All right. Well, based on, and Ms. Gillette, the information in the motion is what your evidence would show if we went to court?
It would.
All right. I do find the defendant has violated her probation as alleged in the motion to revoke probation, and the affidavit in support of that motion Now I'll proceed to disposition, which means what should I do about the fact that she's violated her probation a second time around? So she was set, and then in the first case, Ms. Blades, do you take the same position in both cases, 24 CR 122 and 25 CR 69? That's what the evidence would show.
In the second one, I didn't have a vehicle, so
I understand.
okay.
And Mr. Fibber is going to talk
And they
about
didn't take it on
Okay.
my case in Lyon County. And I had assumed that that was going to be the option when I had agreed to probation in the first place. They had said that they were going to have it moved to Lyon County so that I was able to abide by probation.
Mr. Fibber, do you want to go ahead and let her testify?
I'd rather not, Judge. I think we're good. I think we'll just have Ms. Gillette make her recommendations and then we'll follow after.
All right. Well, I find in both cases that the same information is true and correct, with the exception that she only had prior revocation in the one case and not in the other, in the later one. Ms. Gillette, recommendations for disposition on these violations?
Judge, it's going to be our recommendation that she serve her underlying. Ms. Blades is not amenable to probation. I don't believe that she has afforded herself a treatment in either case. It's been a lot of not taking responsibility. If you don't have a car, you make arrangements for rides. If you are testing positive, you ask your CSO for treatment before you come in here. You make an admission and you say yes. Ms. Blades, I have added up her jail credit, and I have it all compiled. Her underlings are each 12 months. I believe Mr. Fibber is probably going to ask for a reduced sentence if the court says to serve her underlying. I went back and looked at the cases as to whether they were concurrent or consecutive. I don't have notes in the 25 CR 69 case that it was consecutive to the prior case. If they ran concurrent, it would currently have a 12-month underlying if they're concurrent there. And she had 20 days of jail credit on her original. Mr. Fibber and I were talking earlier, and I thought it was 145, but it's actually 148 days.
Well, let's look at that. There was 20 originally at sentencing, and then the next journal entry, there was a specific amount put in there.
She had 90 days to do, and she had 87 days of jail credit and should have had 3 more days. It was 520. She had 11 days, 5/3/25 to 5/14/25 on the one case, and then she had 5/27/25 to 8/12/25. Then she had 8 of that is the full 30 days or the 90 days.
All right. So the 90 days is between the two.
Yeah, she had 145.
So 11 concurrent.
So she had then 11/19/25 to 12/16/25. That's 27 days for a total of 145 days. And I have all of that written down. Essentially, I would just ask that she serve her underlying. And if Mr. Fibber asks for a reduced sentence, I'd leave it up to the court. But I just don't feel that she's going to be successful back on probation with all of the issues. Conditions of probation are don't be in a bar. And don't be in a bar that you have a no trespass order on. And then testing positive for amphetamine, methamphetamine, THC, and alcohol. Those are all substances you're not to be using. And she was just here, went right out and did it again. So that's why I don't feel that probation would be successful if she was placed on any kind of supervision.
depressed without my family.
And she was on probation in the 24 case when she was convicted in the 25 case, yes?
Yes.
All right, Mr. Favre, your position.
Yes. So, Judge, I think just to concur with Ms. Gillette's framing, I think we're looking at about a 12-month underlying total because I think both cases are concurrent. She has 145 days. I agree with that. 148 days. I'm sorry. I agree with that math. Speaking to Ms. Blades, there's a lot of things going on in her life that are kind of contributing factors. And I think I would point out that, first of all, she came into this with almost no criminal history. She doesn't have any prior felonies. She obviously has some substance abuse issues. She's not a Greenwood County resident. She's relocated to Emporia. There was some issue with transferring the probation to Emporia that I don't quite understand, and I think that's part of the reason why there was communication issues on reporting. Now, I'm not saying that to just mitigate all of her responsibility, but I think that the note from Miss Morgan notes that she was calling at different times, showing up late. I think part of that confusion is just being out of county, right? I think she was making efforts, and as we all know, people can just choose to drop off the radar, and Miss Blades didn't. She is obviously having behaviors that are substance abuse affected, being in bars, poor reporting, testing positive. So Miss Blades would like me to ask that she be given one more opportunity at probation. She's been in this time since November, I think 17th. She was arrested in Lyon County. She'd like one more opportunity at probation. It is her first time up technically on 25 CR 69, but that was picked up while she was on 24 CR 122. She'd like another opportunity at probation with court order treatment and Miss Morgan to hopefully get an evaluation, help her, and get set up for treatment. That's her request. I think it may not be a bad option, as well as mental health. I have some concerns about her mental health issues as well, not to the extent of like worrying about a competency per se, but I think there's some mental health assistance that could be beneficial there. So that's our request, reinstatement with, and maybe the answer is to have her stay in until a bed can be arranged by Miss Morgan. That's our request. In the alternative, if the court is just not willing to give her another opportunity at probation, we'd ask the court to consider mitigating her sentence based on those factors to something closer to 8 months. She's already done almost 5. She'd have an additional 3 to do. As I said, she has no ties to this county anymore. So we asked the court to consider letting her move on quickly and get back to Lyon County.
Well, I became involved with this case, as you all may recall, sometime in 2024. There was a concern that she was taking her young child, very young, to a convenience store and offering to have sexual relations with that child and customers. Ms. Gillette, did Lyon County ever file that initial case?
I'm not aware if they have filed any charges.
Well, because of allegations, she had no contact orders put on her in the first case, 24 CR 122. She violated those and was sentenced, given the privilege of probation. Some people think it's a right. But anyway, she was put on probation with certain conditions, one of which was to continue with the no contact orders. While she was on that probation, she went out and got another conviction, the 25 case, for having contact that she was ordered not to have. The complaint that started all of these 2 cases, was June 13th to 24. And I am going to take a little extra time because I think the history in this is very important. The journal entry of plea and sentencing, and this is in the 24 CR 122, was filed November 28th of 24, just barely a year ago. The journal entry of plea and sentencing, the charges had been amended down to 1 count of misdemeanor violation of a protection order, a Class A. It was amended down, so she had the benefit of having some felony orders amended down to misdemeanor, one misdemeanor, and she was put on probation. Adult Court Services Supervision ordered, again, November 19th, 2024, and the plea and sentencing filed November 28th, 24. That was the journal entry filed. The first affidavit for request of probation came March 28th, some 4 or 5 months later. Request that she had violated. A warrant to show cause followed, motion to revoke probation accompanying it. Let's see, information. I see a warrant to show cause return filed May 6th of 25, so it took that long to get that warrant served apparently and returned. There was a probation for revocation hearing filed August 19th of 2025. I'll call that up. On August 12th of 2025 in 24 CR 122, there was a revocation hearing for violation of probations which were found. And at that time, the defendant was ordered to do a 90-day jail sanction with credit for time served to be released after she'd served the time, and she was extended for 12 months from that date, August 12th of 2025, just a few months ago. October 30th of 2025, just 2 months later, there was another motion to revoke probation filed. That's again in the 24 CR 122 case, alleging the new violations that we've been talking about today. Now, moving on to the 25 case that we're also here on today, in 25 CR 69, a new charge, violation of protection orders, again was filed, and that complaint was filed May 19th of 2025. There was a journal entry of plea and sentencing filed August 19th of 2025. Adult Court Services Supervision ordered. Conditions of probation and notices filed October 28th of 2025. I'm sorry, October 28th. So by October 28th, she'd already, in that short of time, between the 19th and the 28th, she was already getting requests for revocation of probation. She was to go down to see her probation office, and she didn't. She was late. The warrant to show cause October 29th. The official motion filed by Ms. Gillette was October 30th. And so, no, she was not on probation very long in the 25 CR 69 case before the request was made. And I think she kind of intimated about that a while ago. But the thing is, she's been under court supervision all this time, and it doesn't seem to be getting through to her. She was told not to have contact with certain people. She violated that quickly. She was put on bond and or probation, told don't have contact. She did it again. And so she's not just having small violations. She's having a new case in Greenwood County. Granted, that has not been resolved yet, but she did tell her probation officer, Miss Morgan, that she had been arrested for trespassing in a bar where she was not supposed to be as part of her probation. I tend to agree with what I've heard from the state that the defendant is not amenable to probation. I think we can keep putting her back on it and maybe even having her do a 90-day dip in the jail, but I think she's just going to keep violating. So at this time, I do revoke her probation in both cases. And I'm going to order that she serve the balance of her sentences in each case with credit for any and all time she's already earned to date. And the jail will need to figure that. They probably already figured that for Miss Gillette, but they'll need to officially figure that for the journal entry. And I haven't heard any good reasons why I should reduce that sentence at this point in either case. So those are my orders. Miss Gillette, please journalize accordingly. Thank you both. Thank you, Miss Morgan.
So what is that? How long does that give me?
Well, the jail and the attorneys will figure that and put it in the journal entry. I'll have to approve it, but we need to actually confirm. It sounds like Miss Gillette may have had a pretty good handle on it, but I want the jail to confirm it.
Okay, thank you.
It's an underlying sentence of 12 months, Ginger, minus time served.
Okay.
Right.
All right. Thank you, Your Honor.
And since the case journal entries don't address whether they run concurrent or consecutive, and one was committed while the other was pending, case law will have to direct that.
Thank you. Have a nice day.
You too. We are in recess.
All right, go back to that. Number 2 on the calendar, Donald Shue. Am I saying that right? Sheu.
Yes, Your Honor.
OH versus
Pleasure.
Bruce Auto. So I see plaintiffs are here. Do I have anybody from Bruce Titus?
Yes, Your Honor. Yes, Your Honor.
Mr. Rayberger. Okay. All right, we are ready to move on with the cases that apparently were not successful at mediation. So the first ones that were back is number 2 on the calendar, Donald Shue, Sheu, and Young OH versus Bruce Titus Automotive Group. It's case number 39050. All right, both parties are here. All right. Mr. Shue, are you ready to proceed?
We are, Your Honor.
All right, go ahead. You're the plaintiff.
All right. If I may we proceed in the order where my spouse, Jung Oh, states kind of her factual recounts of the events where she was present, and then I can follow on with further testimony.
All right, go ahead.
I have a little cold, so my voice might give out, so I'd like to apologize in advance. Okay, so we went to go buy a car. I work for a company that has a link for Jeep dealership to get a discount, and there's like all this discount and all these deals with the Jeep. And when we went there, first of all, they didn't honor it. And then we wanted a specific car, they didn't have it. So they asked us to test drive a car that they feel that is right what we wanted. So we test drove that car, but they didn't have it in stock. So they asked us to get an older car that's in a lot that will go in our price range. So we did, and it's not ideal what we have, but that's what was available during that time. We test drove that car, okay. So we test drove a different car. They wound up selling us a older car, and they asked. So it started during the day. The whole process took the entire day, and then when it was come nighttime, they're telling us to take the car right now, the older car that was in a lot. So my concern was, it's really dark, it's kind of raining now, so I can't really see the defect. So I suggested, can we come back tomorrow? We don't have to necessarily take it today. We can just come back tomorrow. And they're extremely insistent that we have to take the car that day. So we said, can we just, okay, so since you're so insistent, and once again, we offer them that we're gonna come back tomorrow during the broad daylight that we can see the car. And they just keep on pushing us to take it that night. So they brought it into the dealership. They chamoised it off. It's still kind of wet. So, you know, just being a trusting nature, we drove it home, which we lived close by back then. We go home and there are all these defects. So when we went back, we talked to the Ben who sold us the car. He referred to Michael, who's I believe he's a general manager or who's in charge of the entire situation, and they said they're gonna take care of it. So after that, we were finding all these defects. So at this point, when we go back, I mean, when we found the defect, Michael's like, okay, bring it back. I think the other gentleman was Jason, like he's in a, maintenance, or I don't know the title, quote unquote. So when we went back, we're pointing out all the stuff that is wrong with the car. It just, instead of repairing it, they make us jump through hoops, or they ignore us. So we go back and they keep on telling us, even though I can visually see there's all this thing wrong, they said there's something wrong with where I'm looking at it. Even if it's like, there's like, for example, there's a lump, but he's like, no, it's a dent. So for me personally, like every time I go, I get such like I feel really nervous going back, because every time I go, Jason is extremely hostile or so mean, to the fact that I went to Michael and go, I'm in customer service. I've been flight attendant almost 30 years. I'm like, I would never treat my passengers or anybody this way. Like I actually get nervous, because I don't know if he's trying to intimidate me or he's just trying to be extremely hostile, so I will leave him alone. So long story short, I don't want to go on and on. So every time I go, it's really hostile or really mean. So I talked to Michael, nothing has changed. And then we went to I think Jason has left, and I think Jeremy came. So I was really relieved, like there's somebody else. So I once again, I go to the dealership, and don't forget it's a retail. Sometimes we go because no one will address it. It's a retail, and then they get mad if we show up. Like your customers show up, you have a retail chain, but you get mad and you're just really upset, and that's your complaint. And for example, I went to Jeremy, same thing, on the appointment. I give him my name. Soon as he hears my name, sees me, extremely hostile and disrespectful from my perspective, okay? Maybe he might have not said it that way, but let me tell you, I was really, really disappointed. Once again, talked to Michael about his behavior. He told us to go to a specific collision because he doesn't see the same thing we see. So what is the place? Collisions?
Capital Collision.
Capital Collision. This is the one that they deal with. Has nothing to do with us. We have never even heard of Capital Collision. We go there and we address the issue, and they're like, oh yeah, this is like something we can't do. We can repair. You just have to go back to Jeremy. And before we went to Capital Collision, which Jeremy told us to go from the dealership, he took all these pictures of defects. So we go to Capital Collision, and we come back, and he said, oh, we're not going to fix anything because you chose to go to another dealership. We don't even have that option. We didn't go to a different dealership. Why did you even delete the photos? I don't understand, because you said we decided to go to dealership. We already specifically told the Jeep dealership that with this specific car, we have to only deal with this specific Jeep dealership. So we weren't sure if it's the company of Jeep that treats customers this way. We wind up buying another Jeep from a different dealership, and they actually is completely, utterly different experience. First of all, they're extremely professional. They don't make you feel like a small person every time you want to address anything, which I have right to because I'm a customer. And I know for them, it might not be a lot of money. For some people, working class, it's a lot of money for us. I mean, I feel like for them, it's no big deal. it's a big deal for us. So the other dealership, they honor all the discount. It was extremely pleasant. If there's any issue with the Jeep, they address it professionally. And you know, to be honest, they don't want us to go back and forth to the Jeep. They hate us showing up, but they never do anything. They keep on saying there's something wrong with you because you're so difficult, so we're not going to deal with you. I'm like, I don't understand.
Ms. O,
yeah.
time out.
Yes.
Right? I need you to address the issue of the damages. So what you're telling me is there was some damage to the vehicle that you did ultimately buy that Bruce Titus Automotive will not repair. Is that correct?
Correct.
All right.
I can go through the sequence of events and refer to specific documents, Your Honor.
All right, go ahead.
Okay. So, you know, I've tried to get organized and practice a little bit as I reference documents. So please interrupt me at any time, Your Honor, for clarification. I propose I'll start with the amount. I had exchanged emails with your staff at the court about a different amount than what we had originally filed, and I can explain that. I can refer to two specific documents that I think really highlight kind of the key points. I can walk through a little bit about the tone and how we arrived and the motivations on how we ended up with dealing with Olympia Jeep and Bruce Titus Auto Group, and then also highlight key differences in the dealership experience, which I think is actually relevant for what has happened, since we were told by Jeep that we must address these issues with Olympia Jeep, since they had initiated the original warranty repair that was determined to be faulty and needed addressing by their own vendor. So on the amount we're requesting, with our legal fees and the estimates that we were provided by Olympia Jeep and Bruce Titus Auto Group's vendor, Capital Collision, the totals are actually in excess of $11,264.95. And we submitted those documentation. It's in the file, but we are aware that the statutory limit or the limit for small claims is $10,000, and we are understanding that and willing to undergo that threshold. So factually, what I would like to point to in our pages of submission in our plaintiff exhibits is a September 26, 2025 email. It's in the index enumerated as number 5, I believe in the system. It's the PDF of number 8. So this is Rick Conley, who is a manager at Capital Collision. He is, again, they are the vendor that was selected by Olympia Jeep to address the warranty defect that the Jeep dealership accepted. And what they state there is that they had determined what needed to be addressed to correctly repair the item that they attempted to address originally. They had advised both Jeep and the dealership, which they never acted on. So it was really in frustration of them not following through, and also a bizarre interaction we had with the Jeremy Pullar, where prior to us arranging for dropping off the car for being readdressed by the collision department, we highlighted a new defect where we asked for an opinion, and what Jeremy Pullar, besides being very hostile on that visit, insisted that it was a ding when it was clearly a protrusion. We ran our fingers over the protrusion, demonstrated that it was a protrusion. He kept insisting it's a ding. He directed us to Capital Collision to have their opinion. They confirmed that it's a protrusion, that they would have to address that, and that would be a warranty item. And they told us that they would address that. Jeremy Pullar subsequently on follow-up told us, or told me in a phone call, that he had deleted all of the pictures. Well, we have documentary evidence in email submitted bear with me, sir. August 26, 2022. It's page 60 on the index. It's probably going to be further down. Email to Michael Titus is the title page at 65. And expressed to Michael Titus, who was the general manager at that time, that at no point did we state that we were going to another dealership. And in fact, we told Jeremy that we could not, that Jeep told us that we would void our warranty if we address this anywhere else. There is a procedural matter that I brought up with your staff in email, since the opposing side had submitted records from Jeep themselves of our interactions with Jeep, where we would have records within their CRM records that they had stated this. And the only evidence we have are emails that we have sent stating that. So we did ask for cooperation from Bruce Titus Auto Group to provide that full record. They denied that they have access to that. So if there are ever any questions as to whether or not we should be addressing this with Bruce Titus Auto Group or with Jeep, I do want to highlight, Your Honor, Jeep had told us that we must deal with Olympia Jeep and Bruce Titus Auto Group. And, we have no access to those records. And your staff said that there was no mechanism to really compel that. But at no point did we state we would go to another dealership. It was a bizarre turn of events. When we dropped off the car with the collision, we on our own had to arrange for a rental car. The dealership refused to cooperate with us. The rental agency was very surprised in that they have a group account for any kind of warranty claims that they would just submit that. Jeep independently authorized the rental reimbursement. It was during pandemic. It was going to be far more expensive than $50. And they failed to honor that essentially as well. Only recently, a few months ago, did they send us a check for the $309. I did submit evidence on that as well. Factually, there is a letter. We culminated after the bizarre incident, after not getting our issues addressed. We did retain an attorney trying to get some supervision over this and get attention to have somebody truly address the outstanding items that we have been very consistently addressing. We've always been cooperative. We've always been friendly, despite the characterizations and the opposing side's submissions. Their response from Davies Pearson, factually has a number of issues. In their submission and our submission, we have the letter response from Davies Pearson in, again, pages as in submission. In the file here is title page 19. It's probably going to be more like 20 something in the PDF. Here it is. Title page October 19th, 2022. Page 25 in the PDF, Your Honor. Their page here, their letters begins 26. Some factual issues with their letter is one, in paragraph 3, they assert that while the original vehicle we ordered that was in transit, we decided against that car. The true fact is we attempted originally several months prior. There's an email I have submitted with Daniel Rayberger, who is on the call today, where we attempted to purchase cars my wife had detailed with the special employee discount pricing, with the special incentives that was advertised by Jeep. They had promised they would honor all that. In the email, we detail how the staff delayed. They then sold the car that was in inventory that we wanted to purchase, proposed to us to order. Why we needed a car at that time was my wife's base of some 20 years in Hong Kong for United Airlines was closing. They were moving her base to Seattle and she would need to commute. We ordered the car. They promised that there would be no second sticker. They would honor the employee discount. They would honor any advertised leasing specials. And delay. The car was not going to arrive in time. They told us that they would add a $25,000 second sticker on top of the MSRP. They told us that they would not honor any lease specials and they would not honor the employee discount. At that point, we needed a car before the end of the year. They presented us that they would give us at full MSRP a 3-row SUV. At that point, we were fully committed to needing a car. We drove the car, decided we would accept the car, given that they would not add a second sticker, they would do full MSRP. And subsequently, when we went to contract for the car, the salesperson, Ben Wright, proposed that not to sell us the car that we had test drove because it was a newer vehicle in the inventory, proposed an older car because it had a lower MSRP because of its ship date. As my wife recounted, we stated that we were fine with taking delivery the next day. They insisted. We inspected the car together. Factually, again, in this letter, on the 4th paragraph, saying that after the sale, we contacted the dealership. This all happened contemporaneously while we were purchasing the vehicle on that same date. Factually, that is incorrect. And page 42 in my submissions will highlight that we were present. We made the discoveries together. There's many issues here where they say we were not timely in advising. I would want to highlight they have accepted the original warranty repair, that it was theirs. Their vendor attempted to repair it. Their vendor has stated what needs to be done. Their vendor on the additional items have inspected. In terms of their own submission of their text messages with the Jeep representative, the pictured car in their submission is not a Jeep Grand Cherokee. It's a Jeep Wrangler. And at no point did they ever have a Jeep representative inspect the car physically. We've never gotten any documentation from Jeep denying warranty claims. We've only had, conveyances of messages by the dealership in which we have no confidence. And in their own vendor inspected the car, provided the estimate, has confirmed the damages and what needs to be addressed. And in fact,
right,
the warranty repairs that they did, again.
Mr. Shue, please. I've granted you here almost 15 minutes to present your case. And we've only gotten from 2021 to 2022. We don't have all day to get where you want to go. What I understand is you're telling me this was not a very enjoyable or pleasant experience in dealing with Bruce Titus Automotive. I get that. What I want to know is the damage that's involved. You've given me a number of $11,264. Is that where we are in this case? That's what you're seeking from Bruce Titus Automotive. Is that correct?
That is the total financial impact to us. We understand there's a $10,000 limit. We have submitted the estimates from Bruce Titus Auto Group's own vendor, Capital Collision. Those are present here in our submissions, starting from page 11, Kylie Friend from Capital Collision. Again, this is their vendor.
Right. I've seen some of those documents. So that's where we are at this point. I think I understand what your side of this is. I want to hear from Bruce Titus, Automotive Group at this point. Is it going to be Mr. Rehberger or Mr.
Yes.
Pilar?
Yes, sir. Okay, so I guess I'm a little confused of what the claim is of the 11,000. My understanding, the concern was there's a dent or ding or protrusion on the hood. If we go back to the timeline we submitted, they purchased the vehicle on 12/11/21. On 12/11/21, Mr. Shue sent an email in telling us of some scratches on the vehicle. There was nothing mentioned about the hood on that date. The next day, Mr. Shue comes back to the dealership, points out a couple additional spots where there were scratches. According to our records, there's still no mention of a dent at that time. He comes back on the 13th, so 2 days later, and now mentions the dent on the hood. Our team had a tough time seeing it because the way the light reflects and it isn't very obvious. So we submitted the photos to Stellantis. And I think this is where, to us, the crutch of this case is, as the dealership, we don't provide warranty. That is the manufacturer. And so they have to decide, is this a workmanship issue or quality defect or not? We just administer the process. So we submitted the photos. They did agree to repainting the hood. And so we scheduled an appointment with Capital Collision on January 18th of 2022. And so at the same time, there was a radio update so we did that on 12/17. On 12/21, we had our detail crew buff all the scratches and take care of those things. Candidly, during that process, we had damaged a piece of the spoiler. We replaced it, and Mr. Shue was okay with the replacement. And so we took care of everything that we could do at our level. It took them 2 weeks to pick up his vehicle because they were waiting for the correct daylight during wintertime to inspect the repairs we had done to the vehicle. So we waited the 2 weeks. They came in. According to the statements from our employees, they spent about 45 minutes looking over the vehicle. Let's see. The rest of this stuff is very detailed in our timeline. So I think we fast forward, and I think all this comes back down to the hood. And again, as the dealership, we didn't manufacture the hood. We don't control the manufacturer. So he mentions that we deleted the photos, which, yes, we did delete the photos. I think it was a miscommunication because Mr. Shue reached out to me at the end of August and stated that we deleted the photos. And when I talked with our people, they said, we thought they were going to another dealership. Now, I don't understand why Stellantis, Jeep, the brand, had told the Shues they couldn't go to any other dealership because truly the warranty is covered at all dealerships across America. So I don't know if there was a misunderstanding or miscommunication, or if Stellantis was stating, we're not going to do anything about your hood. We don't think this is a workmanship issue. And so if you're going to get any hope, maybe it's the dealer will take care of it just out of the goodness of our heart. So I don't know why Stellantis said that, but the warranties go to any Jeep dealership. He mentioned the photos of the wrong vehicle. That's not the case. If you look at the photos, it's actually a reflection. They have a very dark colored vehicle. And when you're looking at the chips in the paint that he was concerned about, it's a car next to it that's reflecting. And Mr. Shue, I thought the same thing. They're like, oh, this is a Wrangler. But when I asked, they said, no, that's just the reflection. And you look at it, you can see it. So that's, I think, a unfair portrayal of what's happened. I think that's the crutch of it for us. I mean, truly, at the end of the day, I think Mr. Shue's complaint about the product itself is with the manufacturer, not with the dealership, because we don't control what they built. And their concerns about the customer experience, I am sorry if we did not meet your expectations. I mean, that we always want people to feel like they had a good experience and they would want to refer their friends and family to us. But ultimately, I guess it's not a crime if we don't meet those expectations. So
You agree, Mr. Rehberger, that this matter was referred over to Capital Collision for review of the hood area?
yes, it was sent to Capital Collision because initially we submitted to Stellantis and they said they'd repaint the hood. So Stellantis paid, Stellantis being Jeep, they paid to have the hood repainted to try to fix what was perceived as a blemish, I'm assuming, in the photos. And so that was done. And then Capital Collision did that repair. And then they stated that, well, that's the best we can do with paint. And I think they actually painted it a second time. Mr. Shue would have to confirm that. And, they said eventually, no, the hood would have to be replaced to change that because, as the aluminum heats up, it's going to continue to form back to that shape. So.
And so once you learned that situation from Capital, that the repair that was necessary was going to be a replacement of the hood and blending in the paint from the hood and the other areas of the vehicle in the front. What happened at that point?
We sent it, so it had been declined by Stellantis. They told us, no, we're not replacing the hood. Then we reached back out to our rep in the area, the local rep, and said, hey, can you review this again? They're telling us no. And he came back and said, nope, it's, let me see, I think it's in our thing here. They declined to repair the paint. Okay, yeah. So they said they're not defects in material or workmanship. So they went back to their language in their policies as Stellantis, the manufacturer, and said, nope, it's not a workmanship or manufacturing defect. And that's where we don't control what they decide.
You saw yourself this vehicle?
I have not personally seen it, no.
Oh, okay.
Jeremy is on the call.
You're referring to your records and notes.
Yes. Yeah, all the communications we had.
So basically, Bruce Titus is throwing up its hands and saying, we have no responsibility for this. Even though we sold you the product, we don't stand behind it. Jeep stands behind it. If Jeep says it's not a problem, we didn't do it, somehow or other, this thing failed, but it's not our problem either. Is that the position of Bruce Titus and Jeep?
The part of the position is they took delivery on 12/11, and I understand that they're saying that they asked not to take delivery but they emailed us on 12/11, not noticing anything at the hood. On 12/12, they didn't say anything about the hood. On 12/13, now there's a mention of the hood issue. Now, I'm wondering if part of Stellantis's denial is time passed. I mean, we've seen cars get into accidents minutes from leaving a lot after purchase. And so was there outside influence for a potential defect to the hood? Potentially. And so again, they're looking at saying it's not a workmanship issue. We are saying we administer between the manufacturer. If there's a defect in what they do, we perform the warranty on their behalf. But again, we don't control what they approve or don't approve when it comes to these types of issues. We have small control over mechanical things, which is what our service departments do, but not over body shop type items because we don't have a body shop and we can't. They have to approve those things.
Mr. Shue, do you have a response to this?
Yeah, Your Honor, page 64 and pages in submission, there's a listing of all the defects we had brought up besides the dent. The dent was accepted as a repair. That was the original repair, was the dent is highlighted in Rick Conley's email. That repair was incomplete because they needed a hood, which they requested. On page 83 in the—
Mr. Shue, what's the date of that acceptance of the dent as a issue?
It was immediate. Michael Titus, the general manager, inspected it. They submitted it, and it was something like 11/13 and 11/14. Because of pandemic, they could not schedule the body shop for several weeks. whenever it was, returned the car. At that point, Bruce Titus Auto Group and Olympia Jeep managed it in the relationship with Capital Collision. They handled it. I picked up, dropped off at the dealership. Subsequently, I noticed paint defects from the repair, and that was what they were addressing. And then at that point, Capital Collision highlighted that the dent was still there and that they needed to replace the dent as per Rick Conley's email.
So that is December of 2021?
Somewhere abouts there, yeah. December 2021, and I think the body shop actually attempted the repair somewhere in January is when they scheduled me finally. And then it was February highlighted that the repair was insufficient and needed to be readdressed. And we did submit full evidence of those communications. It was always the dent. It was not a paint defect. The paint defects came from an improper repair. Your Honor, on the topic of, whose fault is it? Who is it? Again, without access to the CRM from Stellantis, I don't have the record of the representative from Jeep telling me I must address all of these issues with the dealership. All I have is in page 3, Bruce Titus merged page number, (1) is my email to Stellantis, U.S. Customer Care. Hi, Lucas. I tried calling the 866 number on Thursday. Received no call back. Jeep refuses to address the outstanding items, including the dent that remains in the vehicle. Here in the second to last paragraph, Karen, your case manager stated I may not visit another dealer to address the items Olympia Jeep refuses to address.
Mr. Rehberger, anything further on your part?
I think we did address the issues. Again, there was some confusion because my team thought that they were going to another dealership. I don't know why Stellantis would tell Mr. Shue he had to work with us specifically, but I believe him. I don't know why he would lie about that. So, but we did submit all the things to Stellantis. This wasn't because we didn't do something. We did give Stellantis the opportunity to take correction, and they told us we are not replacing the hood. And I guess one point of clarity, the hood isn't $11,000. So, I know he's claiming he has these damages for $11,000, but the cost of the hood is, I think $800. So again, why Stellantis wouldn't provide a hood, I wish they would have, but they didn't. So that's why we're here.
Mr. Rehberger, do you know if your local representative came and looked at the vehicle?
I do not know if they physically came or not. I know we sent them photos.
Your Honor, we submitted an email August 26, 2022, immediately after visiting Jeremy Poular, where we stated it was very bizarre that he claimed that we said we would go to another dealership. And in fact, we said, Jeep tells us we cannot go to any other dealership. So we have submitted evidence of us alerting Olympia Jeep that we never stated to Jeremy Poular. And in fact, he directed us to go to Capital Collision to address the new issues and get their opinion, where he insisted it's a ding. And Capital Collision again confirmed the new defect in the paint that bubbled up after the heat wave was a protrusion. And it was a bizarre interaction.
Your Honor, Jeremy's on here. I don't know if you want his statement.
Okay, so as far as the interaction goes, I have emails from Don that said in June that he would be stopping by the next week, and I told him Tuesday through Friday between 8 and 4 would be the best. I believe Don didn't show up until August, and not in between one of those days. We did take photos for Michael Titus so that he could resubmit to the manufacturer. The hood defect was initially sent to Capital Collision. They did address the paint. Don signed off on the repair order that everything was good at that time, and took the vehicle. As far as any new issues that the vehicle may or may not have had, I only have record of the hood. I was not actually here in November, December, January during the initial. But he only came in for the paint defect on the hood, and we submitted it at that point. Capital Collision does warranty their workmanship as well, and I believe they offered to repaint the hood for him at that time. As far as not being able to go to another dealership, I actually have records that he's had warranty work done at I-5 since then under warranty, so he has been able to get warranty work done at another dealership.
All right, Mr. Fuller, let me ask this question. You've seen the vehicle?
Correct.
And what's your response to the hood situation? Is it a ding? Is it a paint issue? What did you see?
I seen what appeared to be a minor ding. Very hard to see at that. That's why I referred them to Capital Collision. If it was a paint issue, they had repainted the hood, and they do warranty their workmanship for the repair that we'd done for Stellantis. So if they're saying that it needs a hood at that point, the repair that was done initially in January, I'm going to say that that dent wasn't there. I wasn't here in January, but this is appears to be a dent, not a paint defect from what they're saying. So what happened between August and January, your best guess, because I wasn't here in January during the initial.
Your Honor, I do want to distinguish. The hood was a dent, a new paint defect, which we alerted Jeremy in email, and we submitted August 8th, 2022, highlighted a new paint defect on the driver's side rear passenger door. And Capital Collision confirmed, Jeremy, during our visit, my wife was there, kept insisting it was a ding and not a bubble or a protrusion. Capital Collision confirmed on their inspection it's a protrusion, and hence generated a estimate at that time and an updated estimate based on their inspection of the defect. And they told me, they advised Olympia Jeep of that per Jeremy's instructions for us to have them inspect that specific door. And we have emails we have submitted very consistently highlighting new issues, other issues. Jeremy's assertion that we've had other warranty work done is a non sequitur, because specifically what Jeep was referring to is the defroster grill, the paint defect, and the dent on the hood. That is what we're saying. They told us we must address those issues with Olympia Jeep. They said that having anybody else interfere would void the warranty. They were not referring to subsequent mechanical warranty defects. We've never made that claim.
All right, got it. As I said in the presentation to everybody in this case or in court today, these cases get to be terribly complicated. This is something that's been going on for 4 years or 5 years at this point. Pictures, no pictures, new damage, old damage, new car, different car, switch cars. Who's responsible, who isn't responsible, really, really a difficult situation. I'm in the business of practicing law, and I think the only people that are lower on the list of folks that you have confidence in besides lawyers is car salesmen. And quite frankly, this doesn't help that impression as we look at this. Olympia Jeep says, it's not us, it's Stellantis. Stellantis says, not us, we're not fixing anything, everything is fine. Capital Collision says, this hood is bad. Nobody will accept any responsibility for it. You know, whether these purchasers went to another agency, another dealership or not, I'm not sure what that adds to the equation here, to tell you the truth. I think Olympia, Jeep, Bruce Titus, Stellantis, whomever on that side of the equation owes these folks something for this car. Now, I don't know all that goes into that $11,000 that you're claiming, Mr. Shue. What I want to know about is what's the damage to the hood? What is Capital Collision saying about the hood?
Specifically on the hood, Your Honor, it is in their estimate that they generated September. It is page 12.
Your Honor, can I interject for a second? When we mediated the first time, we offered...
Mr. Rehberger?
Yeah.
Not yet.
Okay, sorry.
I'm listening to Mr. Shue.
Okay.
The conclusion, sum total on the hood repair to address it is $3,627.02.
Does that include replacing the hood and then blending in the paint?
Yes, it does, Your Honor.
All right. Mr. Rehberger, go ahead.
So when we talked with Capital Collision when this thing started several months ago, they told us because it would be a redo of their work that they would repaint the hood if they could get a hood. So, I mean, I guess from that standpoint, if we can provide a hood and give it to Capital Collision and they'll do it under warranty, does that solve the problem?
Was this discussed in mediation?
Yes, that's what we offered in the last mediation. And it was declined.
And Mr. Shue, that's not acceptable to you. You want money.
We have other items here, Your Honor, that they refuse to address. We've submitted documentation that we've brought them up and they've refused to submit it. Jason, the prior service advisor, straight out point blank told us that these warranty submissions takes hours of his time and he makes no money on it because he doesn't get paid a commission. They refuse to take care of their work, and Jeep tells us that we have to go through them for these 3 very specific items.
And Your Honor, if I may, it's not just, I'm so sorry. Is that okay if I speak, Your Honor?
Go ahead.
Okay, if I may.
Consuming an enormous amount of time, and there are a lot of folks that are waiting for time today as well.
Okay, it's not just to mention, it's not just the repair, right? How many times do we have to go to your Jeep and physically go there and deal with all this abuse and mental distress? I'm gonna be honest with you. That's how mean you guys are to us. So when you're saying, what's the big deal? Just take whatever you can. For me, personally, I can't believe how mean you guys were to me. You guys are not nice people.
Well, that's neither here nor there, and that's not something as Miss O, please.
Yes.
I've heard your unhappiness with the treatment that you received through this. Okay. I heard how you feel like you were intimidated and compelled to buy this car. This is even the car that you wanted, some car they got off the back lot, apparently. I don't know where it came from. Yet they want to attribute to you that as soon as you drove it off the lot, maybe this damage occurred, but there really wasn't a damage. It was just ding. It's not a workmanship problem or materials problem, because Stellantis says it is, even though we don't know exactly what Stellantis saw or they didn't see. And all these other issues, I don't get. Okay. I really don't. To my mind, I'm not sure why you bought the car in the first place. I think you should have, when they said, no, you got to take it today or else, you should have said, or else. But that's neither here nor there. That's 4 years old of of bad advice that I'm giving you. I'm really stumped as to what to do here. You know, I understand what Mr. Rehberger and Mr. Polar are saying about, well, you know, it's Landis's problem, not ours. I really don't like that. I think there's a connection here that shifts all the burden to the purchaser and the old concept of purchaser buyer beware. But I still think that it has to be something that is reasonably available for the buyer to be able to protect themselves under the circumstances. Hold on a minute. I want to think about this a little bit. Okay. Can I just reschedule it for a presentation of an order?
Yeah, that would be fine. Do you want me to?
January 16th? Yeah.
Okay. Yeah, I can add this to. Yeah, we can add it to the 16th.
All right. All right. There's an awful lot here that's been presented in terms of paperwork. Mr. Shue keeps referring to different parts of his presentation in this, and I need to look at that. I've heard all the testimony I want to hear in this case, but I'm not prepared today to render a decision on this. I'm going to have this reset for presentation of my response, my decision in this case on the 16th of January. And should we set it at a specific time or do we set that other one? All right. We'll try to do this one first after we do the other parts of this. All right. That's what I'm going to do at this point. I appreciate you all being here. I'm sorry this has been such a difficult proposition for all of you. Mr. Shue and Ms. O on their part, having to make multiple trips to the agency. I'm sure the agency isn't not happy having to deal with them every time they come in the door. But there was a problem here that should have been addressed that apparently wasn't addressed and now is thrown into the court's lap to try to resolve it. So I will, but it'll be on January 16th.
Thank you, Your Honor.
I have one question. I'm a flight attendant, so it's really hard for me to move around my schedule. I am scheduled on the January 16th. Do I have to be physically available, or can I just have my husband take over, or do you want me to?
Mr. Shue is fine being here. I'm sure he can represent the two of you in this case.
Okay, thank you so much.
All right.
Sorry for getting worked up, Your Honor. Tried to be organized with the document, but.
Mr. Rehberger, Mr. Polar, thanks for being here.
Thank you, Your Honor.
That's all for today.
Thank you, Your Honor. Appreciate it.
This is number 8 on the calendar. Stephanie Daly versus Mary Baker and Matthew Schultz, SCHULTZ. It's case number 39357. Both parties are present today. Apparently unsuccessful in their discussion to resolve this case. So it looks like this comes on today as a counterclaim.
Or maybe yes.
So Ms. Daly, did you file a case against these folks previously?
Yes, Judge. Your Honor, what happened was since January, when this was a previous phone call that my sister made and decided to play fake victim, and my niece's husband claimed that I threatened him with a knife when I never had a knife. It turned into a domestic violence suit. And this happened when I was recovering from breast cancer, and I never threatened to kill him, and I never threatened to kill her. So
let me try to focus here. Did you file a claim against?
Yes, I did. It's over
Baker
my belongings. Yes, it's about
me-
my belongings. And I had, while I was sorry, Judge.
Ms. Daly, has that case been resolved?
The case is still pending because what happened was she had sold all my belongings when she was told not to by the judge that is handling the case between us. And I had to file the case in all my belongings that she was told not to sell. And she claimed that there is an email.
Hold on, Ms. Daly, which judge, which court case are we talking about?
The
A
court
small
case,
claims case?
this court case is filed by me. The case that she has against me, we are currently in, that she refused to resolve.
And is that here in this
Not in this
Thurston
court.
County Small Claims Court?
In this Thurston court, yes, but not in this small claims. This one is mine. So if you really think about it, the court case that she filed against me, theirs is the domestic violence. Mine is the small claims, which is mine. She's trying to countersuit mine.
Wait. So my initial question was, did you file a small claims case
against her?
Against Ms. Baker for
my
damages to your property?
Yes.
You did. That case is still pending? Is that what you're saying?
No, the other cases that she has against me is pending.
That's the criminal case?
Correct.
All right.
That's why I'm trying to say there's that going, but this one is the one I filed that we're here for today. She's trying to countersuit that.
I'm still confused, Ms. Daly.
I know. It's kind of confusing. I'm trying to figure out myself how that turned out to a countersuit.
Does Ms. Daly have another case pending in this court, a small claims case?
I can take a look.
Yeah, I'm kind of confused myself because the last I checked, I filed this.
So another small claims case, but different.
Yeah, different. It looks like it's not related to this. It's by this.
May I shed some light on the situation?
And you are Mary Baker?
I am Mary Baker.
Go ahead. I don't want all kinds of background. I don't want threats. I don't want civil stuff or criminal stuff.
Correct. So we received notice in our mailbox that she is suing me for property. I am therefore counterclaiming for rent and utilities, non-payment of rent and utilities.
All right. That I get.
Yes.
I don't get, a counterclaim is filed in a case that's originally filed by the other party. They make a claim and then you file a counterclaim.
Correct.
But we're not finding a case filed by her.
By her? Ms. Daly filed and we got notification of it right here, if that helps.
Yeah, let's see it.
Okay. This is what was dropped off at our.
39357. That's this case number.
Yes, that's the initial claim that was filed, and then there was a counterclaim filed.
So why am I confused?
Judge, it's for the property that was in the home. She was told not to touch the property. My belongings. It's my belongings that she had sold, that she was told not to touch, Your Honor.
All right, so it appears that on October 9th, under this case number, 39357, Ms. Daly filed a claim against Mary Baker and Matthew Schultz for $10,000 for loss of property.
Mm-hmm.
Now,
it's my belongings. All my belongings.
Ms. Baker, what day did you file your counterclaim?
I filed my counterclaim. I filed my counterclaim on the 14th of October.
So right after you've received this notice of claim.
Yes.
And I was not served.
Was that served on Ms. Daly?
It
No.
was served.
No.
Ms. Daly, please.
I tried to serve her via mail, certified mail. The and all its belongings was returned to me. The envelope was mailed to her last known address in care of Bess Owens. I do have an email or a text message from Bess Owens stating to the fact that this is where all her mail and all her work stuff was to be sent to. And the next process in that was that all of her business mail was also going to be sent to this address. So that address, I then forwarded the notification, but it was never picked up. I got that returned back to me about 2 weeks ago. Unfortunately, envelope with me, but it was sent via UPS or USPS, and it was never picked up from that facility, and it was then therefore mailed back to me about 2 weeks ago.
Nope.
Ms. Daly, you're saying that you never got notice of this counterclaim?
Mr. Judge, Your Honor, there's a reason why I did.
Ms. Daly.
Yes.
I don't need a long description. I asked you a question. You can say yes or no. Did you receive notice of this counterclaim? Yes or no?
I do not have an address, so I did not receive no notice. I don't even receive any mail, so no.
That's enough.
No. And she's my abuser, so no, I don't. She's an abuser.
Yes, I'm Mr. Schultz.
Go ahead.
To address, since the topic of serving was brought up, these documents were never properly served to us in the first place. She left the serving paper connected to the whole document and had put it in our mailbox while she has a restraining order on us. Well, we have a restraining order on us. I don't know if that changes anything or that's anything.
So, Chase, we don't have a notice of service or an affidavit of service on Ms. Baker and Mr. Schultz on the original case.
Yeah, we haven't received any proof of service.
And we don't have any proof of service the other way.
If I had the envelope from USPS saying that I tried to serve that, would that have been proof?
Service.
That I tried to serve?
Not attempted service. Service means she gets the paperwork and she can see what it is that you're doing, so she can prepare herself for court. In the same way that you're raising the issue of notice. I mean, I realize there's something else going on here that's got a lot to do with what's happening that is not particularly relevant right now for this court. What we need to do is ensure that Ms. Daly gets notice of the small claim. You've obviously gotten it because you're here and responding to it and you file a counterclaim. You can raise the issue, it wasn't properly served. I get that, but you're also here. You know it, that it exists. I don't know that Ms. Daly knows that she's been sued in response and seeing the documents in relation to that. that's the baseline here for the court to be able to go forward in this case and hear her claim for you selling property that you were told not to sell, and for your claim saying she was to pay you rent and utilities for some period of time. Ms. Daly, we need to get you a copy of Ms. Baker and Mr. Schultz's claim against you. Where can we deliver that? Where can they deliver that so we can have another hearing in this case?
Never, because they caused me identity theft. So no.
Ms. Daly, that's not the issue.
No. I don't have an address. No.
Well, you are someplace right now, obviously.
I'm fleeing from my abuser. They abuse me, so no. I don't want anything from them.
Ms. Daly, you need to cooperate in this process. You want me to sit here and make a decision on your claim, but you're refusing to participate in the process by allowing them to file a counterclaim against you.
I'd rather go to trial. I mean, what more am I going to do? What? I don't have an address.
Where can they send the documents so that you can pick them up so you can be prepared to respond to their counterclaim?
I don't know. I don't have an address. I'm not a Washington State resident, so I don't live in Washington State, so I don't have an address.
In Washington State, you have an address somewhere?
No.
And I understand you may not want to disclose that address.
I do not.
You're not leaving me with a whole lot of options here, Ms.
Because
Daly. They have a right.
I don't
Ms.
have a lot
Daly,
of option. Yes.
They have a right to file a counterclaim against you and have that heard in court. At the same time, your claim against them is heard.
Mm-hmm.
So if you're not going to cooperate, you're not leaving me any choice but to dismiss your claim as well.
And I don't have, well, you could send it to, I don't know, I can pick it up at a post office. I can do that.
I'll tell you what we're going to do, Ms. Daly. We're going to reset this case.
Mm-hmm.
You're going to contact the court here. You know how to do that. You're obviously here on Zoom.
Mm-hmm.
And provide the court with an address, be it a post office, be it whatever it is, that they can send the document. And they're going to send it to you by regular mail, not by certified mail. So there's no question about whether you picked it up or you didn't pick it up.
Okay.
They're going to send it by regular mail, and
Okay.
it will be presumed to have been delivered to you at that address. And you will then be in a position where the court can hear testimony from both sides about this case and make a decision as to whether they owe you something for loss of property or you owe them something for not paying rent and utilities.
Okay. That's fine by me.
So I'm going to give you until, let me look on the calendar. Where do you want to go with the next hearing date?
Our next available hearing date is March 6th.
Okay. All right. So Ms. Daly, you're going to contact the court and provide a mailing address by January 9th.
Okay.
If you do not provide that mailing address by January 9th, your case will be dismissed.
No problem. Thank you, Judge.
Hold on. We're going to reset the case then for hearing on March the 6th on your claim against them and their counterclaim against you. So be prepared to deal with both issues. Your responsibility to present your case, your responsibility to respond to their case.
All right.
Understood?
Thank you. Thank you.
All right. Thank you, Ms. Daly.
Bye.
Bye.
And that, ladies and gentlemen, that is how that ball of yarn unwound today. I just don't know what to say. I watched those small claims matters live, and I caught myself making faces the whole time. My jaw dropped. I laughed a little bit. It was all just a little bit crazy for me. I hope you all enjoyed it as much as I did. And I want to thank you very much for coming out and hanging out this afternoon with us at the Court Gallery for this live weekend review. This is not all that happened this week, but it is all that we have had time to show today. But be sure, there will be more, so stay tuned. Make sure you have that like button hit, subscription button hit, and get all those notifications with the bell icon and all that kind of good stuff. Because, ladies and gentlemen, we will be back with more court. Maybe tomorrow. Maybe today. Who knows? We'll see. Ladies and gentlemen, I am your Lone Wolf Usul. I'm your host for these here videos. I'm your curator for this here channel. And I thank you very much for tuning in. And before I go, I do want to say a very special thank you to some very special people like Zach with his $10 contribution, Granny with her $10 contribution, and Wendy with her $5 contribution. Thank you so very much for your support to the channel, and we'll see you next time. The dogs say goodbye too. Thank you all. Merry Christmas. If I don't see you before then, come back soon. We're doing this every single day. Later, guys.